Owning rental property in California doesn't fail overnight, it fails quietly, through laws most investors never see coming. In today's video, 10 California landlord laws that could destroy your investment in 2026. The dark side of rental laws. We're exposing the legal rules that are reshaping California real estate and turning solid investments into high-risk liabilities. These aren't rumors or opinions. These are documented laws and regulations already affecting rental income, eviction timelines, operating costs, and long-term property ROI. We'll break down how certain landlord-tenant laws, rent restrictions, and property management requirements can legally limit your cash flow, increase your exposure to lawsuits, and trap investors in properties they can't easily exit. Some of these laws impact new buyers immediately. Others only hit after you've owned the property for years, when it's already too late. Sit tight as we unveil how these laws work, why they exist, and how they quietly punish unprepared property investors across California. If you care about protecting your capital, understanding investment risks, and making smarter real estate decisions, watch this video from start to finish. Because the final laws on this list are the ones investors underestimate the most. Hit that like button, subscribe to the Globe Realty, and stay informed before your next investment decision. Number 10. Strict anti-discrimination and screening laws. At first glance, strong anti-discrimination and tenant screening laws might sound like common sense. But in California, these rules aren't just well-intentioned. They're among the strictest in the country. And if you're a landlord who doesn't understand them down to the letter, they can destroy your investment and leave you exposed to major legal risk. Here's the hard truth. In California, you cannot ask about, consider, or base decisions on anything tied to a protected class. That includes race, color, national origin, religion, sex, disability, familial status, gender identity, sexual orientation, source of income, and more, as defined under the Fair Housing Act and California's own Fair Employment and Housing Act. But it doesn't stop there. Starting in 2026, new screening rules require landlords to provide written screening criteria upfront before charging fees. Process completed applications in the order received and approve the first qualified applicant. Refund screening fees if the applicant isn't selected. Provide the applicant's own credit report and an adverse action notice if you deny them based on that screening. Let that sink in. If you have a poorly documented screening policy, apply criteria inconsistently, or keep screening fees without issuing required refund notice paperwork, you can face civil penalties, lawsuits, actual damages, and attorney fees that often exceed $10,000 per complaint before trial costs. Ask yourself, do you have documented uniform screening criteria? Have you updated your forms to meet 2026's written disclosure and refund requirements? Could one misstep today cost you tens of thousands or more tomorrow? These laws were designed to protect renters, but in practice, they're a minefield for landlords who aren't meticulous. Stay ahead of this, or risk turning your rental liability into a legal nightmare. Number 9. Local ordinances can be worse than state law. When you invest in California real estate, the statewide laws, like AB 1482's rent caps and eviction protections, are just the baseline. What most investors don't realize is that cities like Los Angeles, San Francisco, Berkeley, Oakland, and others impose rules that are even stricter, and they can override state law when they give tenants greater protections. Here's the kicker. Cities with local ordinances often limit rent increases far more tightly than the state's cap of 5% plus CPI, max 10%. In San Francisco and Berkeley, local caps on annual rent increases are frequently well below state limits, sometimes tied to a fraction of CPI, meaning landlords may only be able to raise rent by 2 to 3% in a year, even if inflation is much higher. And it gets stickier. Some municipalities require landlords to register and report rent data annually, justify increases with documentation, and follow extra eviction criteria beyond just cause, adding layers of bureaucracy and liability that can delay rent adjustments or evictions for months. There's even controversy over local price-setting rules. Berkeley passed an ordinance banning the use of rent-setting algorithms by landlords, arguing they harm renters. The software firm RealPage sued the city, claiming the ban violates its rights. Do you know all the cities where your properties are located and their specific ordinances? Could a city's local rent ceiling be half the statewide cap? Are you prepared for registration fees, reporting requirements, and enhanced eviction thresholds? Failing to navigate these local rules can cost you income, time, and legal fees, even if you're fully compliant with state law. That's the ugly truth about local ordinances in California, and it's why many investors are reconsidering holding property at all. Number 8. No lockouts, legal evictions only. This one shocked new landlords the most, and it's why it lands on this list. In California, self-help evictions are illegal, period. That means you cannot change the locks, shut off water or electricity, remove doors, or touch a tenant's belongings, even if they haven't paid rent in months. Do it anyway, and the law doesn't see you as a frustrated landlord, it sees you as the one in violation. Here's the hard data. Under California Civil Code, illegal lockouts can expose landlords to actual damages, statutory penalties of up to $100 per day, plus attorney's fees. In real-world cases, landlords have been hit with 5-figure judgments for trying to speed things up outside the court system. And speed matters because legal evictions in California are slow and expensive. As of 2025, the average uncontested eviction can take 90 to 120 days, while contested cases regularly stretch 6 to 12 months or longer, especially in tenant-friendly jurisdictions. During that time, you're still paying the mortgage, taxes, insurance, utilities, and maintenance, with zero rental income. How long can you float a property with no rent coming in? What happens if the tenant knows the system better than you do? Here's the controversial part. The law heavily penalizes landlords for mistakes, but barely penalizes tenants for abuse of the process. A tenant can stop paying, delay hearings, file procedural challenges, and still remain in possession, while one wrong move from the landlord can flip the case entirely. Even removing abandoned property incorrectly after a tenant leaves can trigger liability. California requires strict storage, notice, and disposal procedures, and violating them can still cost you damages. This law was designed to prevent abuse, but in practice, it transfers leverage almost entirely to the tenant. For property investors, that means higher risk, longer vacancies, and unpredictable cash flow. If you're investing in California, understand this clearly. There are no shortcuts. One emotional decision can turn a bad tenant into a legal and financial nightmare. Number 7. Duty to mitigate damages. This is one of the most misunderstood landlord laws in California, and it quietly eats into investor returns. Here's the rule. If a tenant breaks a lease early, you are legally required to mitigate damages. In plain English, you cannot leave the unit vacant on purpose and charge the tenant for the remaining months. California law expects you to actively try to re-rent the property at fair market value. Sounds reasonable until you look at how this plays out in the real world. Under California Civil Code and long-standing court precedent, landlords must show good faith, documented efforts to find a replacement tenant. That means advertising the unit, responding to inquiries, showing the property, and not setting rent unreasonably high just to keep it vacant. If a judge believes you didn't try hard enough, your claim for lost rent can be reduced or wiped out entirely. Now let's talk numbers. In many California markets, average days on market for rentals have stretched beyond 30 to 45 days, and in some rent-controlled areas, it's even longer. During that time, you're still paying mortgage, insurance, taxes, utilities, and maintenance, but the clock is working against you legally. How do you prove you tried hard enough to re-rent? What if the only applicants don't meet your screening criteria? What if market rents have fallen? Are you expected to lower rent and absorb the loss? Here's the controversial part. The burden of proof is on the landlord, not the tenant. A tenant who walks away early can argue you failed to mitigate, even if the market simply wasn't there. And if the court agrees, you may only recover a fraction of what the lease promised. For property investors, this turns leases into conditional agreements instead of guaranteed income streams. Your downside risk is capped, but your upside protection is limited by law. This rule exists to protect tenants, but in practice, it shifts market risk squarely onto landlords, especially during downturns. And when combined with rent caps and screening limits, it makes California rentals far less predictable than many investors realize. Number 6. Habitability and housing code enforcement. Owning rental property in California isn't just about collecting rent, it's about staying on the right side of habitability laws, or you'll quickly see your profits evaporate. California law is unambiguous. Landlords must provide units that are safe, livable, and fully functional. That doesn't just mean a roof over someone's head. We're talking working plumbing, heating, electrical systems, pest-free conditions, proper ventilation, secure locks, and more. Fail in even one of these categories, and the tenant and the city can come knocking. Here's where most investors get blindsided. Even if the tenant was aware of issues before moving in, you are still legally responsible. Cities like Los Angeles, San Francisco, and Oakland actively send inspectors to follow up on complaints. Violations can trigger fines, mandatory repairs, rent reduction orders, or even lawsuits seeking thousands in damages. A single small code violation, like a leaky faucet or faulty smoke detector, can snowball into a major liability if the municipality decides to enforce it. Let's put some context to this. According to recent data from the California Department of Consumer Affairs, tens of thousands of habitability complaints are filed each year, and hundreds result in fines exceeding $5,000 for landlords who didn't comply quickly. Some landlords have even faced civil lawsuits, claiming the property was uninhabitable, costing them six-figure settlements. How often do you inspect your properties for code compliance? Could one unreported leak or pest issue cost you thousands in fines and lost rental income? Do you have a maintenance system that proves you're actively managing habitability, or are you relying on tenants to alert you? Here's the reality. California's habitability laws are designed to protect tenants, but for landlords, they are a legal landmine. Even a small oversight can destroy cash flow and drag you into court. Stay vigilant, document everything, and treat habitability as a top investment priority. Because in California, neglecting this law isn't just risky, it's expensive. Number 5. Rigid notice requirements for rent increases and evictions. Here's one that catches even seasoned landlords off guard. The devil is in the details. In California, it's not enough to simply send a letter or text your tenant that rent is going up or that they must move out. Notice forms, delivery methods, and timing are all strictly regulated by law. Miss one tiny requirement, a date off by a single day, missing required language, or failing to follow proper delivery procedures, and your entire notice can be declared invalid. That means weeks, sometimes months of delay, while the tenant remains in the unit, and you're still paying the mortgage, utilities, and maintenance. Let's put some perspective on this. Under California law, rent increase notices for tenants in non-rent-controlled units require 30 or 90 days, depending on the percentage increase. But local ordinances often add layers of complexity. Some cities require notices to be personally delivered, posted on the door, and mailed simultaneously, or even certified mail. Skip any step, and courts have repeatedly ruled in favor of tenants, throwing out evictions or delaying increases. Eviction notices are even more complicated. California's just cause eviction laws demand exact statutory language. Use the wrong phrase, misstate the law, or miscalculate the cure period, and the court may dismiss your case entirely. And in contested evictions, delays can stretch 4 to 6 months or more, eating into cash flow while legal fees mount. Are your notices 100% compliant with both state and local law? Do you have a system to track delivery dates, document compliance, and avoid legal pitfalls? Could a single oversight cost you thousands of dollars and months of lost rent? Here's the controversial truth. California's notice requirements are so strict that even well-meaning landlords can be penalized, while tenants have enormous leverage to delay or block action. This is a law designed to protect renters, but for investors, it's a ticking time bomb that can destroy timelines, cash flow, and profits. Stay precise, document everything, and treat notice delivery as a non-negotiable business process. Because in California, mistakes here are expensive. Number 4. Security deposit limits and strict return rules. Here's a law that sounds simple, but if you mismanage it, it can wipe out months of rental income. California has tightened security deposit rules in recent years. For most properties, landlords can charge no more than 1 month's rent as a security deposit. Only very small landlords, owning 2 or fewer units, can ask for up to 2 months' rent. Forget this limit, and you could face legal claims and penalties, even if your tenant caused damage. But here's where it gets tricky. The return process is strictly enforced. Landlords must return the deposit within 21 days of the tenant moving out, along with an itemized statement of deductions. Miss the deadline or fail to provide proper documentation, and California law allows the tenant to sue for up to 3 times the deposit amount, plus attorney fees. Yes, triple damages. Even more, documentation must be clear. You cannot deduct for normal wear and tear, only actual damages or unpaid rent. So a faded carpet or a tiny nail hole? You can't touch it. Improper deductions are a frequent cause of litigation, and courts rarely side with landlords who fail to meticulously itemize. Do you have a system to track deposits, deductions, and timelines? Could a single administrative mistake cost you thousands or even tens of thousands if multiple units are involved? Are you confident your current forms comply with the newest statewide rules? Here's the controversial reality. This law heavily favors tenants. Even small errors, like miscalculating the 21-day window or forgetting a line in the itemized statement, can result in massive financial penalties. For investors, this isn't just paperwork. It's a cash flow risk that can destroy profits if not handled perfectly. Ensure you document every deduction and treat security deposits like a regulated financial instrument, because in California, mistakes here are costly and unforgiving. Number 3. Appliance Mandate. AB 628, 2026. Starting in 2026, California will require landlords to provide fully functioning refrigerators and stoves in every rental unit. This isn't just a suggestion, it's a statewide mandate, and failure to comply can trigger fines, tenant claims, or even legal action. For many investors, especially those with older properties, this adds unexpected upfront costs. Installing new appliances in aging units can easily run $1,500 to $3,000 per unit, and that doesn't even account for ongoing maintenance, repair, or replacement costs. If you own multiple units, these expenses can quickly spiral into tens of thousands of dollars, all before you collect a single dollar of rent. And here's a question for you. What happens if a tenant moves in and one appliance breaks within the first month? Are you prepared to repair or replace it immediately, or risk being out of compliance? The law doesn't leave room for "it was working when they moved in" excuses. The unit must be habitable and functional at all times, which means landlords need active maintenance plans and budgets to stay compliant. This mandate also changes the ROI math on older rental buildings. Investors who didn't factor in appliance costs may find themselves with negative cash flow, particularly in markets where rent increases are capped by state or local laws. Here's the controversial reality. Laws like AB 628 are framed as tenant protections, but for landlords they function as mandatory capital expenditures, increasing both risk and operational complexity. In other words, even if you're a careful, law-abiding investor, this law eats into your bottom line and fast. Number 2. Mandatory just cause eviction rules. Here's a law that transforms how landlords can handle problem tenants, and it's why it's at number 2 on this countdown. In California, once a tenant has lived in your unit for 12 months or more, you cannot evict them arbitrarily. The law requires just cause, meaning you need a legally valid, documented reason, such as non-payment of rent, repeated lease violations, or using the property for illegal activity. No fault. Evictions, like wanting to move a family member in, are strictly limited and heavily regulated. Here's the hard reality. Many landlords assume they can push tenants out if they want the property back. But attempting to bypass just cause rules can invalidate your eviction notice entirely, leaving you stuck in court for months. And while eviction timelines under normal circumstances can already take 90 to 120 days, disputes over just cause can drag 6 months or longer, all while you're losing rent and paying ongoing expenses. Do you have documented evidence for every reason you might need to evict? Could a tenant challenge your notice and stall your eviction, costing thousands in lost income and legal fees? Are you prepared for the courts to scrutinize every step of your eviction process? And here's the controversial part. California law heavily favors tenants here. Even minor procedural errors, like missing a notice requirement or failing to prove a lease violation, can nullify your eviction. Meanwhile, tenants can stay rent-free while the eviction drags on, giving them significant leverage. This law protects renters, and that's important, but for property investors, it's a cash flow trap. Your ability to manage your property, address problem tenants, or recover units quickly is severely limited. Number 1. Statewide Rent Increase Caps, Tenant Protection Act, AB 1482. Statewide rent increase caps under AB 1482. This isn't just a minor annoyance, it's a law that directly limits how much income you can generate from your rental property, and ignoring it can land you in serious legal trouble. Under AB 1482, most California landlords cannot raise rent by more than 5% plus the local CPI, Consumer Price Index, or 10% total per year, whichever is lower. That might sound straightforward, but the reality is far messier. Many cities like San Francisco, Los Angeles, and Berkeley have stricter local rent control rules, which can cap annual increases at 2 to 3%, regardless of inflation or market demand. For investors counting on steady rental growth, this creates tight limits on revenue and cash flow. Here's the danger. Violating these limits, even accidentally, can trigger hefty fines, mandatory rent rollbacks, and lawsuits. Tenants can claim back overcharged rent and even seek triple damages in some cases, plus attorney fees. And in competitive rental markets, where demand is high, landlords often feel frustrated because market forces are pushing for higher rents, but the law strictly forbids them from collecting it. Are you tracking your annual rent increases down to the exact CPI adjustment? Could a miscalculation expose you to fines thousands of dollars per unit? Do you know how local ordinances interact with AB 1482 in your area? The controversial truth: laws like AB 1482 were designed to protect tenants from sudden, unaffordable rent hikes, but for landlords, they cap your upside, reduce flexibility, and create exposure to legal action. Many property owners are discovering that, even in hot markets, your income growth is effectively legislated, and ignoring the rules can destroy both cash flow and investment strategy. This is the law that changes the game entirely for California landlords, and why it's at the very top of our list. If you're investing here, understanding AB 1482 isn't optional. It's mandatory for survival. And there you have it, the wrap-up of our countdown of 10 California landlord laws that could destroy your investments in 2026. The dark side of rental laws. From statewide rent caps and just cause eviction rules, to security deposit limits, appliance mandates, and strict habitability requirements, it's clear that being a landlord in California is no longer just about owning property. It's about navigating a legal minefield. Even small mistakes, missed notices, or overlooked local ordinances can cost you thousands or even tens of thousands, while limiting your ability to grow rental income and protect your investments. Ask yourself, are you fully prepared to comply with every law, document every process, and manage risk across multiple units? Because in California, the consequences for missteps are very real. Here's the takeaway. Laws like these exist to protect tenants, but for landlords and investors, they increase operational complexity, reduce profitability, and make cash flow far less predictable. If you're serious about real estate investing in the Golden State, understanding these rules isn't optional. It's mandatory. If you found this video helpful, actionable, and eye-opening, like this video, subscribe to the Globe Realty, and comment below. Which law shocked you the most, and would it change your mind about investing in California rentals? Stay informed, stay compliant, and most importantly, protect your investments before the law catches up with you.